composition, character, and status of the Holy City of Jerusalem, and from its adoption of related discriminatory legislation and measures. B. How do the policies and practices of Israel referred to in paragraph 18A affect the legal status of the occupation, and what are the legal consequences that arise for all states and the United Nations from this status? End of quote. In accordance with usual practice, I shall not read out the introductory paragraphs of the opinion which set out the main elements of the procedural history of the proceedings. I shall also omit or summarize some of the other paragraphs of the opinion. I shall accordingly begin reading the advisory opinion at paragraph 22. The full text of the opinion will of course be available at the close of the sitting. When seized with the request for the advisory opinion, the court must first consider whether it has jurisdiction to give the opinion requested, and if so, whether there is any reason why the court should, in the exercise of its discretion, decline to answer the request. The court must satisfy itself, in accordance with the requirement of Article 96 of the Charter and Article 65 of its statute, that the question on which it is required to give its opinion is a legal question. In the present proceedings, the General Assembly put two questions to the court. These questions relate first to the legal consequences arising from certain policies and practices of Israel as an occupying power in a situation of belligerent occupation since 1967. Secondly, they relate to how such policies and practices affect the legal status of the occupation in light of certain rules and principles of international law, and to the legal consequences which arise from this status. The court considers that these questions are legal questions. In light of the above, the court concludes that the request has been made in accordance with the provisions of the Charter and of the statute of the court, and therefore that it has jurisdiction to render the requested opinion. The fact that the court has jurisdiction to give an advisory opinion does not mean that it is obliged to exercise it. However, only compelling reasons may lead the court to refuse to give its opinion in response to a request falling within its jurisdiction. Some participants in the present proceedings have argued that there are compelling reasons for the court to decline to give its opinion. As to the argument that the request relates to a dispute between two parties, one of which has not consented to the jurisdiction of the court considers that the subject matter of the request is not only a bilateral matter between Israel and Palestine, but it is of particular interest and concern to the United Nations, and that giving the opinion requested does not have effect of circumventing the principle of consent to judicial settlement. As to the argument that the court's opinion would not assist the General Assembly in the performance of its functions, the court considers that it cannot substitute its own assessment of the need for such an opinion with that of the organ requesting it. As to the argument that the opinion of the court would have an adverse effect on the negotiation framework, the court considers that it is a matter of conjuncture on which the court should not speculate. As to the argument that the court does not have sufficient information to enable it to give an advisory opinion, the court considers that it has before it sufficient information to decide legal questions in a manner consistent with its judicial function. As to the argument that the questions are formulated in a biased manner, the court does not consider that the General Assembly intended to restrict the court's freedom to determine these issues. The court will ascertain for itself whether Israel's policies and practices are in violation of the applicable rules and principles of international law before determining the legal consequences of any such violations. Having examined each of these arguments in turn, the court concludes that there are no compelling reasons for it to decline to give the opinion requested by the General Assembly. The court then recalls the general context of the case before turning to the scope and meaning of the questions posed by the General Assembly. In this regard, the court notes that the questions define the material, territorial, and temporal scope of the court's inquiry. With regard to the material scope, questions A identifies 3 types of conduct, which question B describes as policies and practices of Israel. First, the ongoing violation by Israel of the right of the Palestinian people to self-determination. Second, Israel's prolonged occupation, settlement and annexation of the Palestinian territory occupied since 1967, including measures aimed at altering the demographic composition, character and status of the holy city of Jerusalem. Third, Israel's adoption of related discriminatory legislation and measures. The specific scope of each of these policies and practices is determined later, as the court examined them in turn. Before turning to that examination, the court limits itself to observing a feature common to all of them, namely that the terms of question A assume that these policies and practices are contrary to international law. By virtue of its judicial function, however, the court must itself determine the lawfulness of the policies and practices identified by the General Assembly. In the present case, the court considers that question A requires an assessment of the conformity with international law of those policies and practices of Israel identified in the request. The court considers that in its request, the General Assembly has not sought from the court a detailed factual determination of Israel's policies and practices. Therefore, in order to give an advisory opinion in this case, it's not necessary for the court to make findings of fact with regard to specific incidents allegedly in violation of international law. The court need only establish the main features of Israel's policies and practices, and on that basis assess the conformity of these policies and practices with international law. In terms of its territorial scope, question A refers to, and I quote, the Palestinian territory occupied since 1967, unquote, which encompasses the West Bank, East Jerusalem, and the Gaza Strip. The court notes that the various United Nations organs and bodies frequently make specific reference to the different parts of the occupied Palestinian territory. The court also does so in the present advisory opinion as appropriate. However, the court recalls that from a legal standpoint, the occupied Palestinian territory constitutes a single territorial unit, the unity, contiguity, and integrity of which is to be preserved and respected. Thus, all references in this opinion to the occupied Palestinian territory are references to a single territorial unit. The court further observes that the question mentions measures pertaining to the holy city of Jerusalem. The ordinary meaning of this term is ambiguous and may be subject to multiple interpretations, but the context provides useful clarification in the present case. In light of this context, the court is of view that the question posed by the General Assembly relating to the holy city of Jerusalem is confined to measures taken by Israel in East Jerusalem. In terms of its temporal scope, Question A requests the court to take account of measures adopted by Israel in the occupied Palestinian territory since 1967. However, the court is not precluded from having regard to facts predating the occupation to the extent that this is necessary for the proper discharge of its judicial function. The court notes that the request for an advisory opinion was adopted by the General Assembly on December 30, 2022, and asked the court to address Israel's, I quote, ongoing, or I quote again, continuing policies and practices. Thus, the court is of the view that the policies and practices contemplated by the request of the General Assembly do not include conduct by Israel in the Gaza Strip in response to the attack carried out against it by Hamas and other armed groups on October 7, 2023. Question B has two parts. The first part requests the court to assess how the policies and practices of Israel identified by the General Assembly affect the legal status of the occupation. The court observed that the use of the verb affect points to the possibility that such policies and practices may bring about changes to the legal status. However, the scope of the first part of the question depends upon the meaning of the expression legal status of the occupation in the overall context of question B. In the present context, the court is of the view that the first part of question B calls on the court to ascertain the manner in which Israel's policies and practices affect the legal status of the occupation and thereby the legality of the continued presence of Israel as an occupying power in the occupied Palestinian territory. The court observed that both question A and the second part of question B call upon it to determine the legal consequences arising respectively from Israel's policies and practices and from its continued presence as an occupying power in the occupied Palestinian territory. If and to the extent that the court finds that any of Israel's policies and practices or its continued presence in the occupied Palestinian territory are contrary to international law, the court indicates that it will examine the legal consequences following from such findings for Israel, for other states, and for the United Nations. Having defined the scope and meaning of the questions posed by the General Assembly, the court must determine the applicable law. The applicability of certain rules of international law in the territory concerned depends on the status of that territory under international law. The court first seeks to ascertain the status of the occupied Palestinian territory under international law and then determines which rules of international law are relevant for answering the questions posed to it by the General Assembly. The question posed by the General Assembly are premised on the assumption that the occupied Palestinian territory is occupied by Israel. In its 2004 advisory opinion on the legal consequences of the construction of a wall in the occupied Palestinian territory, the court set out the circumstances under which a state of occupation is established. The court observed that in the 1967 armed conflict, Israel occupied the territories situated between the Green Line and the former eastern boundary of Palestine under the British mandate, namely the West Bank and East Jerusalem. The court affirmed that subsequent events had not altered the status of the territories in question as occupied territories, nor Israel's status as occupying power. In its whole advisory opinion, the court did not express a view as to the legal status of the Gaza Strip, as the construction of the wall did not affect the Gaza Strip. The Gaza Strip is an integral part of the territory that was occupied by Israel in 1967. Following the 1967 armed conflict, Israel, as the occupying power, placed the Gaza Strip under its effective control. However, in 2004, Israel announced disengagement plan. According to that plan, Israel was to withdraw its military presence from the Gaza Strip and from several areas in the northern part of the West Bank. By 2005, Israel had completed the withdrawal of its army and the removal of the settlements in the Gaza Strip. The court notes that for the purpose of determining whether a territory remains occupied under international law, the decisive criterion is not whether the occupying power retains its physical military presence in the territory at all times, but rather whether its authority has been established and can be exercised. Based on the information before the court, it considers that Israel remained capable of exercising and continued to exercise certain key elements of authority over the Gaza Strip, including control of the land, sea and air borders, restrictions on the movement of people and goods, collection of import and export taxes, and military control over the buffer zone, despite the withdrawal of its military presence in 2005. This is even more so since October 7, 2023. In light of the above, the court is of the view that Israel's withdrawal from the Gaza Strip has not entirely released it of its obligations under the law of occupation. Israel's obligations have remained commensurate with the degree of its effective control over the Gaza Strip. The court then turned to the rules and principles that are relevant for answering the questions put to it. These include the prohibition of the acquisition of territory by threat or use of force, and the right of people to self-determination, which are enshrined in the Charter of the United Nations and also form part of customary international law. Further, international humanitarian law is of particular relevance. Israel's powers and duties in the occupied Palestinian territory are governed by the Geneva Convention relative to the protection of civilian persons in time of war of August 12, 1949, to which I shall refer as the Fourth Geneva Convention, which is applicable in the occupied Palestinian territory, and by customary international law. Pursuant to Article 154 of the Fourth Geneva Convention, that convention is supplementary to the rules contained in sections 2 and 3 of the Hague Regulations respecting the laws and customs of war and on land annexed to that convention. As the court has observed in its jurisprudence, the Hague Regulations have become part of customary international law, and they are thus binding on Israel. As regards international human rights law, the court observed that Israel is party to several legal instruments containing human rights obligations, including the International Convention on the Elimination of All Forms of Racial Discrimination of 21 December 1965, to which I shall refer to as CERD, the International Covenant on Economic, Social and Cultural Rights of 16 December 1966, to which I shall refer to as the ICESCR, and the International Covenant on Civil and Political Rights of 19 December 1966, to which I refer to as ICCPR. The court recalls that international human rights instruments are applicable in respect to acts done by a state in the exercise of its jurisdiction outside its own territory, particularly in occupied territories. The court further recalls that the protection offered by human rights conventions does not cease in the case of armed conflict or of occupation. Some rights may be may be exclusively matters of international humanitarian law, others may be exclusively matters of human rights law, yet others may concern both these branches of international law. Referring to its Wall Advisory opinion, the Court observes that Israel remains bound by the ICCPR and the ICESCR in respect of its conduct with regard to the occupied Palestinian territory. In relation to CERD, the Court knows that the Convention contains no provision expressly restricting its territorial application. On the contrary, several of its provisions impose obligations on state parties that are applicable in territories under their jurisdiction or in relation to individuals within their jurisdiction. This indicates that CERD is also applicable to conduct of a state party which has effects beyond its territory. In the Court's view, Israel must comply with its obligations under CERD in circumstances in which it exercises its jurisdiction outside its territory. As several participants in the present proceedings expressed diverging views regarding the relevance of the accords signed in 1993 and 1995 by Israel and the Palestine Liberation Organization, also known as the Oslo Accords, the Court turns to those agreements. The parties to the Oslo Accord agreed to, and I quote, exercise their powers and responsibility pursuant to the accords with due regard to internationally accepted norms and principles of human rights and the rule of law. End of quote. The Court recalls that it considered in its Wall opinion that the legitimate rights of the Palestinian people recognized in the Oslo Accords includes the right to self-determination. The Court observed that in interpreting the Oslo Accords, it's necessary to take into account Article 47 of the Fourth Geneva Convention, which provides that the protected population shall not be deprived of the benefits of the Convention, and I quote, by any agreement concluded between the authorities of the occupied territories and the occupying power. End of quote. For all these reasons, the Court considers that these accords cannot be understood to detract from Israel's obligations under the pertinent rules of international law applicable in the occupied Palestinian territory. The Court then assesses the conformity of Israel's policies and practices in the occupied Palestinian territory as identified in question A with its obligations under international law. In particular, the Court's analysis examines in turn the question of the prolonged occupation, Israel's policy of settlement, the annexation of the Palestinian territory occupied since 1967, and its adoption of related legislation and measures that are allegedly discriminatory. The Court appraises